Hey everyone, welcome back to our third module for KNR 382. Now that we have had some time to go over some of those basic legal concepts and terminology, hopefully everyone's on the same page. Now we can move forward with looking at some actual legal concepts and applying them to the field of kinesiology and recreation. So we start by doing that in our unit here on negligence. As you can see, if you look in the syllabus, we're going to be covering this topic of negligence for the next 2 weeks. So this is a fairly big unit for us to look at. There are a lot of applications that we can look at in our field. So it's a particularly important unit, I think. And I think you'll find that too as we move through the semester, that we'll be sort of calling back to this unit often, particularly when we get to our unit on risk management. That is obviously going to involve a fairly big part of your grade with the risk management assessment. So before we get there, important that we lay down some foundation. Okay, so negligence, part one. A couple things that we need to talk about before we actually define what negligence is. First of all, we have to identify this area of law, which is tort law. So negligence falls under tort law. I think I mentioned on day one in class that tort law is a pretty big aspect of the law, and if you went to law school, you'd probably spend an entire semester studying it. We're going to study it in 3 weeks, which obviously isn't quite as long, but there are a couple of different things to acknowledge here in regards to tort law. First of all, you can read the definition there on your own. Basically, what we're looking at when we look at is tort law is a type of civil lawsuit. So that's a bit of a callback to our conversation last week when we identified the difference between civil and criminal court proceedings. Essentially, what's happened in a tort lawsuit is that someone has suffered some kind of harm or wrong because of the act of another person or organization. And essentially, they are seeking some kind of retribution for that wrong. We'll talk about the different types of damages they might seek later on in this conversation. But important to know that basically we're talking about someone being harmed by another person or organization, and this is their filing in a court of law. Now, if you're curious, this word tort is actually a French word that means wrong. So that's where we get this terminology and definition of a wrongful act. Okay, you can see here I've given you a bit of a spectrum to help maybe provide some kind of visual cue here as we talk about tort law over the next few weeks. So you can see on the far left-hand side of our spectrum, we have this concept of negligence, which we're going to talk about today in detail. You can see that negligence falls on the far left side of the spectrum, which is also the green light, right? So in terms of our spectrum here, negligence is the lightest form of tort law that we're going to be looking at in terms of severity and in terms of damages. So we'll cover negligence today. In 2 weeks from now, we'll get into these two other areas of tort law, which you can see are on the other end of that spectrum. So we have reckless misconduct, which falls right in between negligence and intentional torts. I'm not going to get into too much detail on those other two today, but I will have you know that in terms of severity, basically what we're looking at here is negligence. You have a person who had no intent to act and also no intent to harm. So in terms of severity, again, kind of on the light end. On the other end of that spectrum, we have intentional tort. So here you have someone who has both intended to act and intended to harm someone else. So obviously much more severe in the eyes of the law. And then reckless misconduct, as you can see, falls right in the middle there. That means someone did intend to act, but they didn't actually intend to harm anyone. So you can see how that is sort of the middle ground and a little bit more murky in terms of defining what that means legally. Again, we'll get into more detail on those two areas in a couple weeks. Today our focus will really be on negligence, but I think it's helpful to define it in the context of the spectrum so that you can see sort of what we're dealing with in this overall umbrella area of tort law. Okay, So when we define negligence, I sort of already did that on the last slide, but a more textbook type definition here on this page, you can see that negligence is the failure to use reasonable care that results in harm or risk of harm to another person or party. So basically, someone has failed to use some level of care that in turn caused someone else to become injured. Okay, you can see here, and I think your textbook does a nice job of explaining this. Negligence can be either an act of commission or an act of omission, meaning negligence can occur because of someone's chosen actions, but it can also occur because someone has failed to act, period. I'll give you an example of how negligence can be an act of omission. So in this Davidson versus University of North Carolina lawsuit from 2001, one of the cheerleaders who cheered for the University of North Carolina on the JV squad was doing a trick, fell during that trick, and hurt her neck. The family of this young woman sued the university for negligence. And their claim was that the athletic department had failed to hire and properly employ a coach that was trained in this area in cheerleading. So basically, they had a volunteer coach. They weren't willing to invest the money in a full-time staff member who would have the proper qualifications, and therefore it was considered a negligent act of omission, right? They didn't take any actual steps that caused this girl to fall, but their act of omission, their failure to hire a qualified coach, possibly led to her injury. So that's a way to kind of apply this concept of negligence, particularly an act of omission. So negligence can be an actual act or an act of omission. Okay, your book talks a little bit about there being different degrees of negligence. So I won't talk too much more about this, but I just wanted to point out a few things and maybe give you an example to help make this stick a little bit more. So the degrees of negligence here that I've identified are slight, ordinary, and gross. Now your textbook also mentions this fourth level or degree, willful and wanton. And some states do look at willful and wanton negligence as a degree, but I would say for the most part, that's going to dip into our middle of the spectrum when it comes to reckless misconduct. So we're not going to talk about that in the context of negligence this week, but it will come back up when we get to that unit on reckless misconduct. So anyway, we've got these 3 degrees of negligence that we're looking at. And essentially, a court, when looking at a negligence case, is going to ask, what are the details of this case? How severe was the harm or the injuries caused? And, how much negligence is actually involved here, whether it's an act of commission or an act of omission. And essentially, they're going to then decide which degree of negligence we're dealing with. So it could be slight, meaning that, the injuries caused were pretty limited. Maybe someone left a puddle of water on the floor at a rock climbing gym and someone slipped and twisted their ankle. And that's probably going to be considered slight negligence, right? It was something that wasn't severe, didn't cause too severe of an injury, and didn't create a situation that was going to cause a lot of harm potentially. So that's slight negligence. Ordinary negligence is usually how courts will classify kind of a standard case of negligence. For the most part, the cases we look at in here are just going to be ordinary cases of negligence. Basically, if someone who is working in that field, if they would have done things differently, and they had a basic standard of care, and that care wasn't lived up to, we're essentially talking about ordinary negligence. The top of the degrees of negligence here is really gross negligence. So in these cases, we go from someone being careless to someone being extremely careless, to the point where injuries could be severe, and in some cases even death can occur. You might have heard about this case in Missouri. I believe it was this past summer with the duck boat incident. You had a case of complete gross negligence where the captain saw that there was bad storms on the radar but decided to take the boat out anyway. very tragic incident occurred where several people ended up dying because of that. So there's ongoing litigation against that captain who did survive now for gross negligence. Again, that's probably the most extreme example we could look at when it comes to gross negligence, but it gives you an idea of how there are these different degrees of negligence. And certainly the degrees help us define the type of negligence that occurred, but it will also likely help the judge determine what types of damages are awarded in those cases. So that we'll get to in a little bit when we start looking at that fourth category of negligence. But again, this just gives you an idea of those different degrees or levels of negligence. Oh, one last thing. I did upload an article about the duck boat incident on ReggieNet, so if you want to look a little bit more into that case of gross negligence, you can. Okay, so I always like to include an example case as we are walking through the different elements of a negligence case. I think it's helpful. It provides some context so that as we go through these different elements of a negligence lawsuit, you can actually see in real time how they would apply. So I'll give you a minute here to read through this example case, and then we'll just keep coming back to it with each element that we describe. Okay, if you need to read it for longer, just go ahead and pause and come back. But I'm going to go ahead and move on to identifying our elements of negligence here. So in order to actually sue someone for negligence, you have to be able to prove 4 different elements. When we say elements, we basically mean these are legal elements that have been determined by prior court decisions, and now this is the accepted precedent, okay? So when we say burden of proof, which we talked about a little bit last week when we were talking about the difference between civil and criminal cases, here we're talking about a burden of proof that applies to the plaintiff, okay? So we're talking about a civil case, a negligence case, and therefore the burden of proof falls on the plaintiff. So the person who's been harmed or injured, it's up to them, and probably in most cases their lawyer, to prove these 4 elements of negligence exist. Now, in order to be successful in a negligence claim, you have to be able to prove all 4. 3 out of 4 won't do, 2 out of 4 won't do. All 4 have to be present in order for negligence to exist. And so we're just going to highlight each of these briefly. I think your book does a nice job, but I want to try to provide a little bit more context and maybe some examples along the way. Okay, first element of negligence is duty. Okay, so essentially here you just have to be able to prove that whoever you're suing, so the defendant that caused some kind of harm, that they were in a position where they had an obligation to provide some level of care for you or to just keep you from unreasonable risk of harm, right? So they owed some level of duty to you. Now, you might be wondering, how do we know whether or not someone actually owes a duty to keep someone else safe from harm? Well, there are a couple of different origins of duty here that I've outlined. So it could just be a professional duty, right? Someone who is hired as a PE teacher, by definition of their profession, owes a level of duty to the students in their care to keep them safe from harm, right? So that relationship that they have, teacher-student relationship, in it exists a professional duty under the eyes of the court, meaning that as their PE teacher, they owe those students a level of care to keep them safe from harm. Same could be true for, let's say, like an athletic trainer or an event manager or program director. Anyone who, by definition, is overseeing participants or customers is going to have this professional duty to keep them safe from harm. There could be other legal definitions of duty, special relationships. So a parent and a child, by inherently being a parent, I owe a level of care to my son to keep him safe from harm. So that's just an example of that. I'd say primarily what we're going to be looking at in here and what's relevant to your career and recreation is that professional duty. Okay, so how do we know what level of care we might owe someone? That might be another question you're thinking about. Generally, what happens here is the court will say there is some standard of care that we want to measure the actual actions against. Okay, so if we go back here to our example case, this might make more sense. So if this case were to move forward in court, the judge might say, what's the standard of care here when it comes to a storm and, a sporting event at the college level, in this case, Division I level. And they would look at the NCAA policy and see that event managers are supposed to wait at least 30 minutes after a lightning strike to return to play, right? So we know that in that particular case, that's the standard of care expected. That one's pretty straightforward, right? We have it actually written in a manual what the standard of care is. Now, every case is going to be that crystal clear in identifying the standard. And that's where we get into this reasonable person standard, which we'll get to a little bit more on the next element. But just know that in order to identify this first element, basically all the plaintiff has to show is that the person they're suing, the defendant, had some kind of obligation to them and owed them a level of duty to keep them safe from unreasonable harm. Okay, so second element here, if you're able to prove duty, if you're able to prove that relationship existed, then you have to prove breach of duty, or breach as your textbook identifies it. So basically, the defendant who owed you this duty to keep you safe from harm failed to meet the standard of care that was required based on that duty. Again, I mentioned this on the last slide, but generally this is measured by what we call the reasonable person standard. So basically the court will ask, what would a reasonable person in a similar situation done in this situation? Would they have acted the same way? If not, there probably is if not, there probably is some level of negligence. If they would have acted the same way, it's probably okay. So generally what happens in these court cases with breach of duty is, you'll have, maybe some expert witnesses called who work in a similar field, have similar experiences, and can speak to, whether or not the person lived up to the standard of care in that position. Okay. I think it's always important to note when we talk about negligence that K&R practitioners are typically not liable for any kind of damage or injury that occurs because of an inherent risk. What's an inherent risk, you might be asking? Well, I've provided you the definition up here. Basically, these are risks that are inherent to a particular activity, right? We know these risks exist with this particular activity, and we can't really take them out, otherwise we're going to change the nature of that activity and it's not going to be the same. Football is an obvious example here. We know that there are inherent risks associated with tackling in football, right? We know there are head injuries that are associated with football and tackling. But if we were to remove that tackling from the sport, obviously it's going to change the fundamental nature of that activity. So generally speaking, those risks that are deemed inherent to a particular activity are not going to be injuries where the defendant can be liable. Excuse me, I have something in my eye. Okay. Scope of liability and foreseeability. Generally, practitioners are not going to be liable if something is just completely out of the blue or unforeseeable. Okay. So in our example case here with Allie, the event manager, she has the ability to look at her radar on her phone and see that this storm is coming, right? So she knows that this is foreseeable. But let's say that just out of the blue, this storm popped up. There was no radar indication. There were no warnings from the weather service. Just a freak thunderstorm where lightning, shot down from the sky. It can happen. Rarely, but sometimes it happens. In that case, she might be able to argue that there was no foreseeability, right? There was no way for her to know this was coming, therefore she couldn't act to try to prevent it. So in this case, we know more details, and we know that she probably was able to foresee this harm, and she knew that the storm was going to stick around, and she still decided to go ahead and not wait the recommended time from the NCAA policy. So if we, kind of go back to our example case here and try to apply these first two elements, first we start with duty. We know that, yes, Allie does owe some level of duty to this consumer who's at the soccer game to keep them safe from harm, right? She's the event manager, so based on her professional duty as an event manager, her job is to keep those people safe, right? So yes, we can prove that first element in duty. Second element here, breach of duty. Did Allie breach her duty to provide a safe environment to the spectators in the stands? Now, if we apply our reasonable person standard from the last slide, we'd probably agree that, yeah, she did breach her duty here, right? She knew that in those situations, the NCAA says, wait 30 minutes, so we could venture to guess that other event managers in similar positions at other universities probably would have waited that full time, right? If they were following the policy. So because she failed to live up to that reasonable person standard, she likely breached her duty. Okay, so third element of negligence here is what we call causation. So in order to prove negligence, plaintiff has to be able to prove that their action or failure to act actually played a substantial role in causing that injury. Okay, so there has to be some kind of connection here between the actual breach of duty and the injury. Okay, I think the best way to describe this is actually apply it. So I'm going to give you an example case here of where a plaintiff wasn't able to meet this third element of negligence. So in this Bellinger versus Ballston Spa School District case, you had a situation where a PE teacher was monitoring his class. It was a girls' PE class, and the girls were playing flag football during the class. So initially, he's out there monitoring the game, but then at some point decides he's going to go into his office inside the building and check his email. Okay, so is there a duty inherent in this situation? Yes, probably, right? He's the PE teacher. These are the students. He likely owes them some kind of duty to keep them safe from harm. Is there a breach of duty? Yes, he's left the field of play, right? He's no longer supervising this PE class, which is one of his job duties, right? So by not being there in theory, he's unable to properly supervise and keep these girls safe from harm. Now here's where the interesting part comes in. So the PE teacher, while checking his emails in the office, is told that there's been some kind of incident on the field. So he rushes back out to learn that two of the girls had a collision on the field where they hit heads. And so they're both on the ground in need of medical attention. So we're going to get to the fourth element here in a minute, but there are injuries in this case, right? The one element that the girls and their families were unable to prove is this one, causation. Right? They were unable to prove that the PE teacher's failure to properly supervise was the actual cause, or at least a substantial cause, of those injuries that occurred. Why do you say that? Well, basically, they couldn't prove that him being there would have actually prevented that injury, right? He still could have been standing there supervising, and these girls still could have collided. This wasn't something that he necessarily could have stopped just by his presence. Okay, so this was a case where the families could not prove causation. So they were able to prove 3 of the 4 elements, but not that third, and therefore they weren't successful in their negligence claim. So in order to prove causation, you have to be able to prove the link between the actual harm that occurred and the breach of duty. Did he breach his duty? Yes. Nobody would argue that, right? He should have been there. He should have been properly supervising. But his failure to be there properly supervising didn't cause or play a substantial role in those girls colliding. Hopefully that makes sense. I know causation of all 4 elements is probably the one that confuses students the most. So if you're still having questions about that one, let me know. But let's go ahead and apply the causation element to our example case here with Allie. So was Allie's failure to evacuate the stands a substantial factor in the cause of the spectator's injury? Probably, right? If we think about it, her failure to keep the patrons outside, inside, away from that lightning certainly played a role in that spectator being struck, right? Had she followed the policy and waited the full 30 minutes, that person wouldn't have been sitting there likely, and probably wouldn't have been struck by lightning, right? So yes, in this case, her breach of duty, her negligent act did play a substantial role in causing that spectator's injury. Okay, so we're 3 for 4 on our example case here. All right, our last element of negligence here is injury, which we've been alluding to here for the last few slides. So basically, in order to be successful in a negligence claim, the plaintiff has to be able to show that there was some kind of injury suffered in the negligent act. Now, we say injury kind of loosely, and you can see why. We're not just talking about physical injury here, right? We're talking about a couple of different types of injury. So it could be bodily injury, physical injury, which often it is in a negligence case. But it can also be emotional harm or mental trauma that occurs because of someone's breach of duty. I would say that oftentimes the emotional harm or mental trauma is in addition to a physical injury in a lot of these cases, particularly in our field. But it's not required for there to be a bodily injury in order for these cases to be successful. We just know that a lot of our instances are. So you can see here I've outlined 4 different categories of injuries that a court will likely consider in a negligence case. So economic loss, obviously this is referring to some kind of financial loss, right? So you could probably think of some examples here. If someone is injured and they have to go to the hospital, they're going to have some hospital bills, right? So they've lost money that they've had to pay that they otherwise wouldn't have had to pay in those medical bills. If someone's injured and they have to miss time from work, then they're going to lose out on a paycheck, particularly if they're not salaried, right? If they're an hourly employee. So that would be another example of economic loss. Another category of injury here is physical pain and suffering. So that's actual bodily harm that has occurred because of the negligent act. Emotional distress. So someone might have some kind of emotional harm or be suffering trauma, after this negligent act has occurred. If we think about our example case with Allie and the spectator, I've never been struck by lightning, but I imagine that's a pretty traumatic thing to go through. So you can guess that in addition to physical pain and suffering and economic loss, that the spectator also probably has some level of emotional distress, right? That, when it's storming now, they might have trouble going outside, or they might stress about situations that are going to involve them being outdoors. So again, another category of injury that might be considered here if the plaintiff can prove it. Finally, physical impairment. So this particular category of injury is probably more rare. However, if someone has like a lifelong injury as a result of someone's negligence, then they can argue that they have suffered physical impairment. So this could be, someone loses their eyesight because of the negligent act of someone. Maybe they lose a limb as a result of a negligent act. These are things they're going to have to live with for the rest of their life. So this goes far beyond physical pain and suffering, right? That's going to be temporary. These are things that are going to be permanent. So essentially, as the court's determining the proper monetary value for a negligence case, they're going to look at each of these categories of injuries and try to calculate what's appropriate. So someone that just suffers physical pain and suffering from a negligent act, that might be a smaller payout than someone who has also suffered economic loss, emotional distress, and of course, if someone's suffering from a physical impairment or lifelong injury, their payout is going to be much higher, right? Because those are injuries that are going to impact them for the rest of their lives. Compensatory versus punitive damages. So generally when we talk about civil lawsuits and then when we talk about negligence claims, compensatory damages are just the monetary payout that's really just meant to put the plaintiff back into the financial position they were prior to the negligent act. So if someone, loses out on, let's say, $1,000 from medical bills, has to lose some time from work, it's another $1,000. In order to properly put that person back into the place they were prior to the negligent act, you're talking about a $2,000 payout, right? Those are considered compensatory damages. Now, the court can also give out what we call punitive damages, which are monetary damages in addition to compensatory damages. Now, generally, you won't see punitive damages given out in cases of slight or ordinary negligence. Punitive damages are typically reserved for those cases of gross negligence, right? Where the goal of the court is not just to put the plaintiff back into the financial position they were, but also to try to limit those situations from happening again. So to try to deter future transgressions by the defendant. So this is an additional payment they're having to make to the plaintiff. Again, the idea here is to try to prevent these things from happening again. Okay, let's go back to our example case then one last time. We've walked through this case with Allie as we've been walking through each element. We showed that, yeah, she owed a duty to these spectators to provide some level of care, right, based on her professional duty as an event manager. Yes, we think she probably breached that duty by failing to follow the NCAA policy about waiting 30 minutes after a lightning strike. Causation, yes, we showed there was causation, right? Her failure to implement that policy led to that spectator being outside in the stands when that lightning struck. Therefore, you can show a direct link between the injury and the breach of duty. And then finally, our last element that we haven't applied yet, injury. In this case, that one's pretty straightforward, right? We know that this person was struck by lightning and suffered severe injuries because of it. We can make some assumptions. We don't have a lot of information, but we can assume that, of course, there's probably physical pain and suffering from that, right? We know there's probably some economic loss, at least from medical bills, maybe an ambulance ride. We can certainly argue that there probably will be some level of emotional distress. Not sure about physical impairment, but I think we can definitely argue and prove that there's injury here. So because of that, I think, this spectator likely has a pretty solid case against Allie, the event manager, when it comes to proving these 4 elements of negligence. So hopefully that case is helpful in walking through each of these elements and applying them. You're going to get to do this a few times this semester. You'll have an example case study this week involving a fitness center where you're going to have to essentially do the same thing that we did together here with this case. So you'll get a little bit more practice doing this. So if you're still not quite sure about some of these elements, I think some more practice cases will help. Okay, I did just want to mention I did upload another kind of current event in our field that I think is worth reading into, particularly if you think you want to work in youth sport, particularly if you think you want to work in football. So there's an ongoing negligence lawsuit against Pop Warner football from 2 moms whose sons ultimately died as a result of their CTE injury suffered while playing youth football. This is a pretty prominent negligence case going on right now, and I don't know that it's being reported a lot, by the media or even in the national news, but the implications of this could be huge in terms of maybe shifting precedent or even the way that we structure the rules for youth football. So I did upload this article to ReggieNet, so definitely take a look. I think it's also another case where you can start to apply some of these concepts. Okay, so you might be thinking, well, who can be sued in a negligence case? Can I be sued in a negligence case? I'm just an intern, or I'm just an entry-level employee. So I think it might be helpful for us to just walk through the different levels of an employment structure where people can be sued and kind of what the level of liability is for each of those levels. So let's start at the bottom here. You can see this is the largest part of our pyramid here. That's the employee and service personnel. So more than likely, if you have a current job in the field, you're probably falling under this category right now. As a junior, senior in college, These are kind of entry-level positions in kinesiology and recreation. These are often front desk employees, trainers, people that are front of the line, right? These are people that are dealing with our customers, more often than not. So these are, as you can see, kind of the biggest group of employees in most organizations. I've used ISU Campus Rec here to sort of provide some context. So you can see at ISU Campus Rec, we've got a lot of employees and service personnel, right? Anyone who's working the front desk would fall under this category. Anyone teaching classes or training folks, they're going to fall under this category too. Now, if you're not already working in the field, your first job is likely to be in this area. So important to kind of know what you are liable for in these situations if a negligent act occurs. So here's the good news. If you are an employee service personnel, you are only liable for your own negligent actions, okay? So if you are negligent or reported to be negligent, all you have to worry about is yourself, right? You don't have to worry about the negligence of your peers or your supervisors or the corporate entity themselves. So that's the good news, right? So you're only liable for your own actions. So hopefully you learn a lot in this class and you never find yourself in that position where you're negligent or being sued. If we go up a level here to the administrative or supervisory personnel, these are basically folks who are in some kind of supervisory role, right? They have people working underneath them. So I've given the example here with Campus Rec. I just pulled up the administration folks on our website. I don't think this is everyone, but it gives you an idea, right? We've got, assistant director, associate director, so on and so forth. These are folks with some level of supervisory experience, right? They are overseeing those employee service personnel. They are overseeing other employees. There are managerial implications to what they do. Because of that, not only are those folks liable for their own negligent actions, they can also be sued or be held liable for the negligent actions of their employees, okay? So where the employee service personnel were only liable for their own actions, these people in administrative roles can also be held responsible for their employees' actions. This is important, right? As many of you, even though you might be service personnel now, in a few years, you might find yourself in one of those administrative roles. And therefore, it becomes even more important that you are in tune with what your employees are doing, that you're providing proper training and supervision of those employees, because not only can you be held responsible or liable for your own actions, you can now be responsible for theirs as well. Finally, you can see the top of our pyramid here, we have the corporate entity. So in this case, we're talking about basically the company itself, the ownership group of the company. In our situation here with ISU Campus Rec, we're talking about the university itself, right? So Illinois State University is the corporate entity in this situation. So oftentimes what happens in a negligence case is the plaintiff doesn't just go after the employee service personnel that maybe was responsible for the negligent act. Maybe they also go for that administrative person that was in charge of them. Often what they'll do is they'll go all the way up to the corporate entity, right? You might be thinking, why would they take the time to do that? Well, typically service personnel making $10 an hour isn't going to have a lot of cash free to pay out settlements or to pay out damages. But they know that corporate entity is going to have cash, right? So oftentimes in these cases, the plaintiff is going to go towards wherever avenue they think is going to provide the best opportunity for damage relief. So in any case, they're going to try to seek that corporate entity, most likely. Now you might be thinking, what's the liability of the corporate entity? The people in charge of ISU probably have never even met the employee service personnel working in Campus Rec. Well, the law doesn't really care, and we'll talk a little bit more about that here on the next slide. So essentially, this concept of vicarious liability, which is different from strict liability that your textbook talks about this week, we'll get into that a little bit later. But vicarious liability basically says that if an employee is negligent, their negligence can be passed all the way up to the corporate entity if the employee was acting within their scope of employment when that negligent act occurred. So basically, a corporate entity can be liable in a lot of negligent situations. And I'll explain a little bit more what this means here in a minute. But I do just want to say, it doesn't matter if the president of a company knows who an employee is or if they have a direct supervisory role. According to this vicarious liability concept, it doesn't matter. As long as the employee is acting within their scope of employment when committing a negligent act, the corporate entity can be sued. Okay. So what does this mean when we say scope of employment? Well, basically it means that an employee has to be working within some authorized time and space limits when a negligent act occurred, right? That means that it had to occur during normal work hours, right? And within a confined space that is considered that workplace, right? So if, a front desk employee for ISU commits a negligent act, but they do it at 3 in the morning at their apartment, that's not going to be a negligent act that's passed up to the corporate entity, right? Because it didn't occur on time and space that would be considered part of their scope of employment. Another point here to make about scope of employment, that as long as the employee acted or failed to act as part of their job duties that were meant to serve the organization, then that's considered scope of employment. Okay, so if we go back to our Allie, the event manager case, we know that part of her job duties were to keep those participants or those spectators safe in the stands, right? So part of her duties were to understand the NCAA manual on thunderstorms and how to evacuate spectators. So in that particular case, her failure to act or failure to get those people out was part of her job duties to serve that organization. Hopefully that makes sense. So basically, what we're talking about in these cases of negligence that don't go up to the corporate entity, those only occur if you can show that the employee conducted acts that were considered outside the scope of their employment, or what we also term as ultra vires acts. So if you're the corporate entity and you're trying to show that, hey, this employee was acting outside of their employment, then you're going to have to prove that in order to get that liability off of you in court. I'll give you another example here to try to provide some context here, because I know this can get a little confusing. So the Smith versus Gardner case involved a college baseball coach. So he had taken his team on the road for a road game and driven the team bus. The team got to this town, got the student athletes checked into the hotel. He got checked into the hotel, and then he went to the hotel bar by himself, had several drinks, ended up getting in his car and driving and getting into a car accident. So the family of the people in this car that he hit filed a lawsuit against the university that this coach worked for. Again, if we go back to our pyramid here of employment, we can see that the coach probably fell in this administrative role, right, as a coach. But the family didn't want to just sue him. They also wanted to sue the corporate entity, which in this case was the university. Again, most likely because they knew they had a better chance of getting substantial damages in this case. So as the university in this case, you can imagine their lawyers are saying, hey, we want to try to prove this guy was acting outside the scope of his employment when this accident occurred. And they were able to do that, okay? So they were able to show that he was, one, working outside of those authorized time and space limits, right? So this was after the team had arrived at the hotel. The students had all been checked in. This was in evening hours, which weren't normally considered to be part of his scope of employment, right? He also left the hotel, right? So he's now outside of the space limits that would normally be considered part of his employment, supervising those boys. And then the employee definitely acted outside of his particular job duties to serve the organization, right? He's clearly not considering his supervisory role that he really should be at the hotel if something were to happen with those boys. So he acted outside of his job duties by deciding to drink heavily and then getting in that car and driving. So in this case, the university was able to show that the employee acted outside the scope of his employment, and therefore they were able to get out of paying any damages in that case. So hopefully that helped provide a little bit of context here with this concept of vicarious liability. I think the biggest thing I want you to take away from this is that just because a lower level employee commits an act of negligence doesn't mean the liability is limited to that person, right? Their liability could also be passed along to the administrator. That liability could be then passed along to the corporate entity. So, that's why it's so important that when you do get into a position where you're in some kind of administrative role or managerial role, that you are well aware of what your employees are doing, that you're providing proper training, that you're providing proper supervision, because that negligence can be passed up to you. It can also be passed up to the corporate